Yeah, this is the pickup app
Let me get out
for
of your
the
hair.
Brady,
Oh,
and it's coming at you.
Okay, and at the end it says BH legal. You can say as in Beverly Hills legal. I mean,
Yep.
you can, yeah. You already, okay, sorry.
no,
Sure.
no need to,
Just got it
no
down.
need to apologize.
There we go. Okay, this is the for between the segments of this show, plus an ad for whatever. Coming at you in 5, 4, 3, 2.
Hi, this is Kerry Fiorelli, JD, adjunct professor of law and host of Law Matters. I'm also the president of Beverly Hills Legal Services. Are you or a loved one facing legal challenges? Well, you're not alone. At Beverly Hills Legal Services, we handle critical legal topics such as estate planning, Social Security disability benefits, and asset protection. Protect your loved ones, keep your affairs private, and get the support and benefits you deserve. For a complimentary ebook on how to avoid probate, just call me at 424-249-0059. Again, that's 424-249-0059, or heck, just email me, bhlegal@yahoo.com. That's bhlegal@yahoo.com, like Beverly Hills, B like boy, B like Beverly, H like Hills, bhlegal@yahoo.com. Now, let's get back to the show.
Cool. Yeah, let's do one more take just for safety.
You bet.
And coming at you, take 2 in 5, 4, 3, 2.
Hi, this is Kerry Fiorelli, adjunct professor of law and host of Law Matters, and also the president of Beverly Hills Legal Services. Are you or a loved one facing legal challenges? Well, you're not alone. At Beverly Hills Legal Services, we handle critical legal topics such as estate planning, Social Security disability, and asset protection. Protect your loved ones, keep your affairs private, and get the support and benefits you deserve. For a complimentary ebook on how to avoid probate, call me at 249-0059. That's 424-249-0059. Again, 424-249-0059, or you can just email me at B like Beverly, H like Hills, bhlegal@yahoo.com. Again, that's bhlegal@yahoo.com. Now it's time to get back to our show.
Perfect. Cool. Now let's well, but let me start the thing right here. Okay, y'all. This is the second half of the second show number 2, and it's coming at you in 5, 4, 3, 2.
All right, welcome back to Law Matters here on 590 on your AM dial, and we're talking to you from The Answer because we want to be able to answer your inquiries, your legal questions right here on Law Matters. Again, my name is Kerry Fiorelli. You can always phone us at 424-249-0059 or shoot us an email at bhlegal@yahoo.com. We're talking about asset protection today and Social Security disability. So keep in mind, if you are filing from Social Security disability, it's going to take a long time, right? The judges, the administrative law judges, are backed up. You're going to wait like 1 or 2 years to have a hearing, unless your case is decided based on the doctor's reports. If you want us to represent you on your Social Security disability case, the prerequisite is several fold. First of all, you must have a letter from a licensed medical doctor saying that you can't work for at least 1 year because of your injury. And they must provide a diagnosis of your disability. It could be mental, it could be a mental disability, or it could be a physical disability. If you have a life-threatening issue, and I hope you don't, you may be entitled to an expedited case. However, like I indicated earlier, I have a legally blind client, and they still have not provided benefits for him. So it can help expedite your case if you do fall into certain categories, but again, it's a long process. It doesn't happen overnight, and I wish I had more control over it, but this is the government, all right? This is the bureaucracy. Maybe Trump can help move things along like he does in every other facet of our lives in government. But right now, as it stands with the Democrats involved, this is a horrible, horrible system, the worst. Anyhow, let's say that you can't work for at least a year and you want disability benefits. You may get up to like $1,500 a month, all right? Now, if the disability office believes your medical doctor, great. They can award you benefits based on that, or you have to go to a hearing. Now, the hearing is not that adversarial. These are administrative law proceedings. There's no, jury. The evidence is pretty easy to introduce. Even hearsay is allowed in an administrative law hearing. And the judge is going to ask you, when did you become disabled? And I'll tell you why that's important in a moment. They're going to ask you if you can work at all. Now, your biggest problem, all right, your biggest enemy, if you will, is going to be the rehab expert who's going to be involved in your hearing. Why are these people difficult? All right, I'll give you an example. I had a minor league baseball pitcher. He was a right-handed pitcher. And he hurt his arm in an accident on his family farm in a combine. I think that's what they call it, a thrasher. Lost his arm, okay? Now, we went before the administrative law judge, and this rehab person said, he can still work because he can learn to pitch with his left hand. Well, this rehab person obviously knew nothing about baseball. It's not that easy just to go from a right-handed pitching system to a left-handed pitching system. But the judge was at least savvy enough to say, hey, that's not the way it works. I know a lot about baseball. I actually used to play baseball in college, and you just don't become a left-handed pitcher overnight. She saved our case. So be careful. These people are your enemies, the rehab people. The judges, they don't really care. Look, they get paid whether you win your case or not. They get a paycheck. They don't really have a vested interest in the outcome of your case. I'm not going to say that they're on your side, but they're not really there necessarily unless you have a horrible judge to hurt your case. The rehab people, however, they're bent on ruining people's lives. I don't know why. I only had one hearing out of hundreds where the rehab person agreed that the person couldn't work. All right, out of hundreds. They get a charge or a bang out of ruining people's lives by saying they can work. Now, this job has to be within your capacity physically and based on your job experience. And there aren't that many jobs that my clients are able to do, hardly any. Now, keep in mind, when you go to these administrative law proceedings, I'm going to be there with you, right? But it's not adversarial, except for this rehab jerk. You're not going to have to worry about a jury. You're not going to be cross-examined. It's pretty laid back, all right? So don't worry about that. The only thing you really have to worry about is the time it takes. Now, how do you pay us? Now, keep in mind, it is illegal in a Social Security disability case to charge an upfront fee. So if you go to some SSDI lawyer or advocate and they want an upfront fee, run away, unless it's an overcharge case, which I'll talk about in a moment, an overpayment case, okay? Now, for an SSDI case, if we represent you and we win your case, we can get up to $9,000 for your case, all right? But a judge has to approve our fee. Where does this money come from? It comes out of your back pay. So if you became disabled 2 or 3 years ago, you're going to get a pretty fat check if you win your case. Out of that pretty fat check, you're going to pay us one time for our fee. This is not an ongoing deal. You pay us one time, and that, after you pay us, you get your benefits every month after that. Like I said, around $1,400 or $1,500 a month. Now, you must file the correct paperwork. 80% of people that represent themselves get denied. About 80% of people that are represented get accepted. Strange how it works, but it's just that way. So you can represent yourself if you want, but you have to fill out the application. You can do it online, or you can go into an SSA office, and you can have an appointment, so the wait's not too bad. But you can go in there, and they'll help you file your application, or we can do it. We can help you with it, right? Then you have to file something called a 3368, which talks about all the jobs that you've had. What are your work limitations? What is your education? And again, we will help you with that. Now, if you hire us, you need to execute or sign off on something called a 1696. That means you are agreeing in writing that we are your sole legal representatives. We're acting in your best interest, of course, and we only get paid if we win your case. We're not going to take your case unless we think we're going to win it. If you're working, all right, don't bother calling us. If you're working, that's a complete bar to getting benefits. Again, you cannot be working. Now, there are some situations that after you get benefits, you may be able to work part-time in some cases. But if you're working now, all right, and if you cannot receive a letter from your doctor proving your disability, please don't call me. I'm not going to be able to help you. So really, actually, there's one other issue. Did you put money into your Social Security account over the years? Now, for some reason, I could be wrong on this, I understand that school teachers, public school teachers, maybe not private, are not entitled to Social Security benefits. Now, I'm not sure if their union provides something for them if they become disabled, but again, if you're a school teacher, you probably cannot get SSDI. I'm not 100% on that. That could be changing, but please keep in mind that if you're a school teacher and you work for a public school, you may not be entitled to benefits. All right, so now you're waiting the 2 to 3 years to get your benefits. You get that big check, and the judge approves our fee. Then you pay us. All right. Now, so far on all the cases I've ever had, I've never been cheated by a client because we do a good job. We want to make sure that you are taken care of. There's one other kind of case for Social Security disability. It's called an overpayment case. If you were working at the time that you applied and received benefits, the Social Security office can technically sue you or file a claim against you to pay that money back. Now, there are two ways to escape liability on an overpayment case. Innocence. Okay, if you didn't know you were supposed to pay the money back, or you thought you paid it back, or you had some kind of mental disability and it prevented you from understanding what you had to do. And the other way is that you cannot afford to pay it back. So, example, I have a client who has a beneficiary under a trust, but he can't get the money yet because his parents are still alive. So really, he doesn't own anything. So he may be entitled to avoid that overpayment if he can prove innocence. He didn't know that he was getting overpayment benefits. He didn't know he had to pay it back, and he can't pay it back. So again, we do charge an upfront fee. It's not much. I think it's like $2,000 to represent you if you are faced with an overpayment. But don't hire us unless they're trying to get like $20,000 or $30,000 out of you. If they only want $500, you can negotiate that yourself. Okay, anyhow, you are listening to Law Matters. This is Kerry, or my friends call me CJ Fiorelli, at 590 on your AM dial. We'll be right back in a few seconds, and we're here to support you, to encourage you to understand your legal rights. And again, we're talking about asset protection and Social Security disability. If you have questions, contact me, 424-249-0059. Look at our website, bhesstateplanning.com, or send me an email, bhlegal@yahoo.com, B like Beverly, H like Hills, legal@yahoo.com.
And that's the show.
That's the whole thing. Oh my God.
Whole thing, yeah.
Goes my way.